So basically, what we are going to see today, it's a little bit of sources of international law. However, I do believe that only present you the sources of international law, it's somehow insufficient. So I decided that this course should be about sources of international law and their evidence. Because one of the things that you're going to have to do and you have to do in this competition is to present the evidence of the existence of the source of international law, not only knowing the sources, but how to prove it and how to present it before a court of law. And so I decided that this course is better called Sources of International Law and Their Evidence, and how to use it effectively at the Jessup. Because what I'm going to try to do and what I try to do is to focus this whole presentation on how are you going to use, on how can you use them within the terrible 20 minutes that you're going to have presenting a case and trying to present two arguments before a panel of 3 or 5 judges. So what we need you to do is for you to be able to effectively present the evidence of the sources of international law in this case. So let's start a little bit of what are the sources of law in general. If we talk about a deontological way and about the creation of the law, the source of the law is the creation and the mode of creation of the law. How each jurisdiction considers that its law is created is completely different. So the source of law will vary from jurisdiction to jurisdiction in the way in which it's recognized and in which the law burns into life in an ontological way. These sources of law need an external manifestation of existence, and as such, what we're going to see and what we are going to be provided with is with the evidence of the existence of the creation of the law. My example is that it's just like making coffee. When you are going to make coffee or tea in some other places, what you do is that you put the coffee in the coffee maker, you put some water, and then you get some coffee to drink. The coffee that you're putting in the coffee grinder and the coffee maker is nothing else than the sources of law. You actually don't care about the source of law, but you do care about the law that is coming from that source. That meaning that the coffee that you're going to drink. However, if I ask you about the evidence of the existence of that source of law, the only thing that you have to do is to open the coffee maker, and I will see the coffee and all the coffee that has been wet and the infusion that has been carried out. So when we're talking about sources of law, we're talking about the process of creation of law that goes beyond a legislative or a parliamentary way of creating written laws. All sources of law generally have a hierarchy. And one of the most ancient ones is the Roman lex citationium. It's from 426 AD. And it was very funny because what they did is that they took these juriscouncils, 5 juriscouncils, and the opinions that they have rendered and the books that they have written. And it was Ulpianus, Gaius Paulus, Modestinus, and Papinianus. And what they said is that for the judge to decide, he was to count the majority of the opinion of these 5, I will say, doctrinaries. And if they could decide in which there was the majority, then that's the reason, or that was the law that was applicable. In this case, we can see that the source of law was the teachings and the writings of 5 dead people, because the last one, Papinianus, died almost 100 years before the Roman lex citationium was enacted. And then they start making this general rule that if there was an even number of opinions, then the one in which Papinianus was the one that would prevail. And then if Papinianus expressed no opinion, and there was still an even number of opinions about a certain controversy that was presented before a judge, then the judge was free to decide ex aequo bono. So what we're going to see here is not only that there's always a hierarchy or a graduation that we must follow in order to consider the sources of law, but that the sources of law by itself are creating the situation and the law that is going to be applied and presented to a certain case. Now, if we're going to speak about international law, there are two kinds of creation for international law. One that is going to be voluntary and the other one that is going to be spontaneous. If we're going to speak about the voluntary creation of international law, we're talking about willful acts of the state that of international agents that are going to create the international obligation or the international law that we want to prevail. When we're going to speak about the spontaneous creation of international law, those are acts that go beyond the will of the state. The state may not be willing to be bound by the rules of international law. However, they are forced and they are bound by the existence of that rule of international law. Said in other words, we can have conventional and non-conventional sources of international law. If we're going to speak about conventional sources of international law, we can talk about treaties, unilateral acts of the state, and unilateral acts of international organizations. If we're going about treaties, well, there's a whole part that is called treaty law. You already know it, and you should know it. And basically, it's the written commitment of two agents of international law. But strangely enough, if we're talking about the conventional creation of international law, treaties are not the only source of international law that we can go. For example, we can go to the unilateral acts of the states that can be either autonomous or linked to a treaty or a rule of customary international law. When we're going to speak about the autonomous unilateral acts of the states, are, for example, when we have unilateral declarations of an act of a state, or if we have a unilateral act for a state that is not in response to another one. But in some other moments, you can have an act of the state that is linked to a treaty or a rule of customary international law. That meaning that is the way in which a certain state is going to make the interpretation or the application of that rule of international law. And also that you can have unilateral acts of the state that are either autonormative or heteronormative. When we're talking about the unilateral act of the state that comprises or it goes as autonormative, it means that the state is going to be bound by itself and only itself to that international obligation that arises from his unilateral act. But in some other cases, the act of the state may want to link and bound also other states. And when they're binding on other states, we're in front of a heteronormative unilateral act of a state. In the very same way, we have the unilateral acts of international organizations. Those are reflected as decisions, and the decisions from either the judicial or the administrative bodies that in most cases are autonormative, but in some other cases might be heteronormative in, for example, the intention of certain resolutions of the United Nations Committee of Human Rights. So what we're going to have here is the recognition that the obligation of the state may come from this kind of conventional creation. And as such, it can be and it should be recognized as a source of international law. But also, we have this other non-conventional creation. And the non-conventional creation means that the will of the state is not of paramount importance in order to recognize the existence of the rule of international law. In this, we can have the concerted non-conventional acts that can be considered as communiques, declaration, and codes of conduct that are issued by states or by international organizations. These by themselves are not non-binding and cannot constitute an obligation by themselves. However, they will constitute the tool in order to make the interpretation of conventional sources. For example, declaration of states on how they make the interpretation of a certain obligation of provision of a treaty. In that case, we have a source of international law that is of non-conventional creation, but it's not binding by itself, but however, is linked to this conventionally created rule of international law. Also, within the scope of this non-conventional creation, we can have customary international law, which we're going to talk a little bit, and we're going to explain a little bit about a little bit further. General principles of law, and I'm placing a little star with general principles of law because doctrinally they may seem, and they might be in some cases a little bit problematic, as we're going to see in a later stage. And also we have subsidiary non-conventional sources. When I'm speaking about subsidiary non-conventional sources, I'm speaking about decisions of international tribunals within the scope of Article 59 of the Statute of International Court of Justice, and I'm also speaking about the teachings of the most highly regarded publicists. That we're also going to see, because I know what you're expecting. I know what you were waiting for me to start doing right now, and that also they are not all the sources, and they are not the sources of international law by themselves. They are the sources that are used in order to reach a decision by the International Court of Justice. That's the difference. If we're going to speak about sources of international law in general, we are not going to circumscribe ourselves only to the list presented in the ICJ, as we have just saw. However, here in the Jessup competition, we are in a simulation of a case before the International Court of Justice. So we're going finally to this beautiful Article 38.1 of the Statute of the International Court of Justice that says that the court whose function is to decide in accordance with international law, such disputes as are submitted shall apply, first, international conventions, whether general or particular, establishing rules expressly recognized by the contesting states. International custom as evidence as a general practice accepted as law, the general principles of law recognized by civilized nations, and subject to the provisions of Article 59. That Article 59 says that the court is not bound by any previous judicial decision, and the judicial decisions issued by the International Court of Justice are only binding upon the parties that were part of that controversy. Judicial decisions and the teachings of the most highly qualified publicists of the various nations as subsidiary means for the determination of rules of law. This, I would say, 5 cases of sources: international conventions or treaties, customs, general principles of law, judicial decisions, and the teachings of the most highly qualified publicists should be regarded for the case of your Jessup case and for the case of your written and oral presentation as 5 boxes. Everything that you're going to present and everything that you're going to say should fit within one of these 5 boxes. If it doesn't fit, then it is not important for the court. And if you cannot provide evidence that it fits within any of these 5 categories, within any of these 5 boxes, then it is not going to be relevant for your case. In this case, Joram Dinstein, a professor from the University of Tel Aviv, has developed a very interesting theory that says that finally all the categories and the set of 5 boxes that are presented by Article 38.1 of the Statute of the International Court of Justice are nothing but strata. Strata is exactly what you're seeing here in the picture. There's different layers of the earth within the ages, and what you're going to see is not the strata by itself, because the strata is within the earth. What you are seeing is the evidence of the existence of that strata, the evidence that this strata is actually projecting itself outside of its existence. And that's what you have to recognize. So what he's going to tell us is that we have 3 different strata within the sources of international law. The first and the most important are treaties recognized by the states. This is the most fundamental strata, or the most fundamental source of international law, because it's going to provide the written and, in most cases, exact extent of the obligations between the 2 parties or the 3 parties, or the parties that of a controversy, and the extent of the obligation within them. Then we can have a strata of customary international law that are rules that will not be written, but however might bound the participants of the controversy. And third, he says it's everything else, because everything else is going to be subsidiary to these 2 main sources of international law. I would like to draw you to attention that we're speaking about treaties recognized by the states that are parties to the controversy. It is not any kind of treaty, because a treaty by itself, if one party is a signatory of it and the other one is not, then can be used as another source of international law and can be categorized as another source of international law. However, it's not going to be a treaty that falls within 31.1.a of the Statute of the International Court of Justice. So, talking about treaties as a source of law, it's written lex specialis, and as lex specialis, what you are going to need, and what you need, is that it derogates any other kind of general law most of the time, and depending on how they are going to be construed. There are cases in which customary international law may derogate a treaty, and also there may be cases in which some other rules, as depicted in Vienna Convention of the Law of the Treaties, that says that if a treaty goes against a rule of jus cogens, then the jus cogens may derogate the treaty, which I'm not going to enter there. And I will strongly suggest you not to enter within jus cogens only if it's strictly necessary. So if that's the special law that both parties have voluntarily agreed and have expressed by written form, then that should be the first obligation, or the first source of law in which the court should go in order to make a decision in a controversy. However, not all the treaties, and for example, on international trade law, we do have a set of treaties that draw all the rules and certain rules in several aspects, as for example, rules of origin. However, you also have holes that need to be filled within the conventional treaty and the conventional source of international law. With that, you can go to the other sources of international law in order to provide a more comprehensive way in which the treaty can be understood. For example, in the North Sea continental shelf case, it's a very old case in the ICJ, and it's one of the classical cases in order to understand customary international law. The court decided that, notwithstanding that both parties were only signatories and have not yet ratified a treaty, they could recognize that certain articles, 3 articles of that convention, were of the Convention on the Limitation of the High Seas, were actually enshrining and codifying customary international law. So the fact that they were not parties of the convention did not entail the fact that those 2 states were not bound by certain customary international law that was already enshrined or was being enshrined at an international convention. Conversely, at the Greenland case, the court decided that the holes and that there were certain obligations that by customary international law was interpreted in certain ways by both states, and as such, the interpretation and the extent of the obligation that was not clear by the sheer text of the convention was to be understood within the customary international law that was presented by both parties. Now, customary international law. You will always have 2 elements, and this is, I think that almost in all the Jessup cases, this is going to be the source of law that you're going to try to apply the most, because you're going to use customary international law either to prove the existence of an autonomous rule of law, or you're going to try to prove that there's a customary interpretation or application of a certain treaty obligation that is not clear. And as such, you're going to be faced with the challenge to prove the existence of customary international law. Its definition within Article 38.1 is extremely simple. It says that it is a general practice accepted as law. It seems very simple. It seems that it doesn't have any troubles. However, it's going to give you lots and lots of troubles, because you have 2 different elements. And in order to provide the evidence, and in order to prove that there's the existence of a rule of customary international law, you're going to have to prove that there's the material element, that meaning that there's this kind of practice or the repetition of the rule, but also you're going to have to prove that there's a subjective element. That means that the countries or the states or the agents of international law that are making this repetition are somewhat desiring to be bound to this rule of international law. And that's what we call the opinion juris. So there are 2 completely separate elements, and as they are 2 separate elements, they each have its sets of rules and each have its sets of providing and into demonstrating the evidence that you are going to present. So let's talk a little bit about this the first material element, or the material element that is general practice. At the end of all, we're going to rely on the external behavior of the subjects of international law. That means that we need an exteriorization and a behavioral exteriorization in order to prove that there is a general practice. You cannot, and since the Wimbledon and Lotus cases, it has been established that we cannot prove the existence of a rule of international law only by acquiescing or by negative acts by themselves. You can provide positive acts, and it involves positive acts by certain ways, but you cannot only provide negative acts, this meaning abstentions to a practice, in order to prove a practice. You may prove that there's some kind of practice and that there might be some kind of practice within a certain region with the abstention of some others. Or maybe you can prove also by exception that the negative acts or an abstention is what constitutes a general rule of a rule of customary international law. For example, if we're talking about the prohibition of piracy, you can prove by the negative acts of the states in which they are not sponsoring piracy that there's a general practice not to sponsor piracy. What do we require in order to make this material element? You have to have repetition during time, uniformity, consistency, and generality. That means that during time, one just isolated case or fact is not going to be enough. There has to be several acts during time, and they have to be uniform and consistent. That meaning that they should go in the same way, maybe by several subjects of international law, and also it should be general. It should be adopted by a generality that can be either a regional set of countries, can be either the universal set of countries, but in any way, it should be the most important countries or the relevant countries in order to the construction of the practice. Practice, for example, in the case of maritime law, is more relevant for countries that have coasts than for countries that don't have them. For example, in the case of Bolivia, in the case of Switzerland, or in the case of Armenia, their practice is not as relevant and as of those states that do have coastal limits or that have access to the sea. Now, concerning the subjective element of custom, is this kind of opinio juris, is that it is accepted as law. It is the recognition by each one of the states that this practice is obligatory, and it requires a positive evidence of the recognition of the validity of the rules in questions. What we're trying to say here with this statement is that we need an exteriorization of the will of the state. Acquiescence cannot and should not be construed as a validation for the opinio juris. And there are cases in which states may have a practice and may consider that as a practice, but is only a committee practice. For example, the case of salutations on international sea law or maritime law. Those salutations are a general practice. They are uniform, but they are not required. No state feels bound to make a salutation from the vessel to one country to the vessel of another. It's made out of committee, out of policy, but it's not a rule of international law because it lacks this kind of opinio juris or these subjective elements. Now, as most specific as the rule of customary law is as specific as the exteriorization of the opinion juris that is going to be required in order to prove the existence of a rule of international law. That means that if we're speaking about regional or bilateral customary international law, then the opinion juris that has to be presented should be the opinion juris of the parties that are construing that regional or bilateral customary international law. If we're talking about a regional customary international law that is, I don't know, being or that is enforced within the countries of Northern Africa, the fact that some other state that is not part of that region considers it binding is not going to be by any way whatsoever relevant to the construction of the regional rule of customary international law. And we're talking about bilateral customary international law. That's going to be even more stringent, because the only elements of opinion juris that should be analyzed is between those two states. Now, usually how this goes is that you're going to say that this certain uncertain rule, it's a rule of customary international law. At some point of the competition, and it's going to be sooner than later, someone is going to ask you, okay, but do you know, agent, which are the two elements of customary international law? And you very proudly are going to say, yes, of course, because I went to the Jessup Latin American Academy. And I learned that there are two elements, state practice and opinion juris. And if I'm your judge, I'm going to feel very, very, very proud of you. But then I'm going to make the following question. So, and it's present the evidence. Because before the court of law, what you have to do is to present the evidence of what you're saying. We're not just going to believe what you're saying. And the part in which most of the teams are going to fail is in presenting the evidence of the existence of a rule of customary international law, because you cannot, or most of the times, it's difficult to draw the difference between what constitutes a state practice and what constitutes opinion juris. And so, for your own sake, I have made this beautiful, beautiful slide in which you say examples of state practice, in which you can say that the state practice can be evidenced by treaties that are not involving the parties. If you remember, when we spoke about treaties about like a couple of minutes ago, I said that the treaties that were a source of international law within the scope of Article 38(1)(a) of the Statute of the International Court of Justice were the treaties involving the parties or recognized by the parties. So what happens to all the other treaties? Well, all the other treaties can be used as a proof of a state practice from the formation of a general or regional rule of customary international law. You can also provide proof of national legislation, and that any set of the majority of the most relevant and important countries for the construction of that rule of customary international law have adopted this solution of this rule within their national legislation. You can also find it in diplomatic correspondence, national legislative and administrative acts of each one of the states. And if you see, I didn't speak about resolution of international organizations, because this is also one of the points in which most of the teams are going to fail. They're going to try to present some kind of resolution from the General Assembly of the United Nations, some kind of resolution from ECOSOC, some kind of resolution from anybody of the United Nations, and they're going to try to say that that's the way in which they're going to solve magically their case. Well, the only thing that you're doing and you're presenting is the evidence of the existence of some kind of a state practice in order to construe a rule of customary international law. But you won't be presenting to the court not even the recognition of the existence of the rule of customary international law. So you have to be wary on the way in which you're going to present any and all the evidence before the court, because you're still going to be lacking the second element, the subjective element, that is the opinion juris. So how are you going to present that? For example, with the intervention of state agents and international organizations. And so this is something that you have to make a differentiation. One thing is the resolution of international organizations. One thing is if I present as evidence and as the construction of customary international law, resolution number so of the General Assembly of the United Nations. But as proof of opinion juris, I'm going to present to you the declarations of the 5 responsible states in which they say that they feel compelled to comply with this part of the resolution, or that they feel bound, or that this and this and this and this, the relevant states are feeling bound within the negotiations and the intervention in the construction of that General Assembly resolution, that they're feeling bound. What we're looking in opinion juris is the exteriorization of the will of the state to be bound by that rule. So we can also check for national policy statements and press releases, official manuals or legal questions, decisions of national courts, because again, as you can see, there's a difference between the national legislative and administrative acts, in which maybe a country has enacted some kind of legislation. But if the national the courts of that country have considered that legislation to be applicable in the same way in which we are going to construe the rule of customary international law, then we may have the evidence for opinion juries in there. We can also present it in the conduct in relation to other treaties, that meaning how the subjects of international law are applying other treaties that are maybe related to the same subject. And in the application of that treaty, they're generating new rules of customary international law. And also, we can show the lack of opinion juries when you have the failure of subject of international law to react over a practice. And in this, you are going to have a stance and to have, I will say, a doctrinary decision to take on whether or not you're going to consider that the persistent and subsequent objective theory that was advanced a couple of years ago, like 30 years ago, by Ian Brownlee, has taken an effect within the construction of the rule of customary international law, or if either the persistent objector may be considered out or unbound to the rule of customary international law if it reacts against the practice, or if it makes a declaration against the construction of that law, whether or not it can be considered not bound by the general rule of customary international law, and whether or not these objections can arise also once the rule has been brought into life, and once the rule of customary international law is already binding the state. How come a state may subtract itself from the binding element of that rule of customary international law by being a subsequent objector? You are going to have a decision and have a stance concerning this, and try to be trying to be consistent in the way in which you're going to present your case. Now, general principles of law, they are troublesome because there's also a stance and a decision that you have to take. You have to take the decision on whether or not you're going to consider them autonomous, or you're going to consider them depending over customary international law. What that means is that if you see at the very end, the general principles of law, the evidence that you will have to provide is that they are applied over a certain group of states. And once they have been applied over a certain group of states, that these states, the courts mainly, are applying them. So you're going to demonstrate that there's state practice and opinion juries concerning a general principle of law. And so you will have to decide, and you have to decide whether or not you're going to consider them that they exist in an autonomous way, or if they exist as some kind of soft customary international law. What I would say, and I'm by no way whatsoever a source of international law, is that while considering them part of customary international law, there might be a theoretical mistake, because we have to consider that there's a difference between the general principles of law and the general principles of international law. If we're speaking about the general principles of international law, I may go with the theory that they are part of customary international law, and the way to demonstrate them is by way of customary international law. But if we're talking about the general principles of law, encompassing almost every kind of solution that is the most logical solution to the most logical problems, then they exist as axioms by themselves. And as such, they do not need any more proof that to show that they're enshrined in national legal systems. So also, don't go at the first moment to try to prove that you're winning your case just because there's a general principle of law, because they're not, they're the second part of the strata that we were speaking about a couple of minutes ago. So the first thing you have to go is go to the first type of strata. In this kind of problems and within the Jessup, I'm almost sure that you're not going to find too much problems or too much cases in which there's a specific treaty rule within the two parties that is subject to interpretation. Cases have arisen, but it's not the common. So most commonly, you will have to prove the existence of customary international law, and in any event, as a supplementary source from the primary source, you can provide the existence of a general principle of law that in any way in international law was used in that same way in the Anglo-American Commission arbitrations. So let's talk about some recognized general principles of law and a little bit of the international cases or the international judgment in which they were recognized as such by the court. We can say that there are general principles of law of general character, like, for example, the general principle of good faith on international relations that arises from the Chorso factory case, and also the obligation to repair once it has been caused a damage that also arises from Chorso. We can also speak about the contractually transposed to treaties. That meaning that it's a general principle of law that actually applies to how you're going to make the interpretation on how certain states are going to be bound to treaty law. For example, the concept and the principle of force majeure that was recognized in the Serbian loans case, and the liberatory prescription case, and the liberatory prescription principle that actually says that once a payment is done, the debtor is actually free of all his previous debts and obligations, as it has been recognized by the highest fund of California's case. There's also general principles of law that applies actually to contentious liability. Like, for example, the principles of the Wimbledon case, the first one and one of the most important ones that requires a causal link between the actions of the liable state and the damage that has been caused. And also, in the Wimbledon case, the principle for integral reparations of damages that says that restitutio of the status quo ante shall be preferred before the restitution in interim and shall cover the complete amount of damages that were caused to the damaged state. There's also principles of law that can be applied to the judicial procedure. That meaning the way in which the court is going to decide and the procedures that are going to be followed and the principles that should be followed before a court of law. For example, res judicata, as established on the effect of the administrative of the resolutions of the effect of the resolutions from the administrative tribunal of the United Nations. And also the no judgment by another party principle that says that in any event, the controversy cannot be solved or should not be solved only by an arbitrator or by a judge that is from one of the contending parties that has what in private law you may call a conflict of interest, as enshrined in the frontier between Turkey and Iraq case. And also you have and finally, we can have general principles of law that are enshrining individual rights. For example, the general protection principle of law from the individual against the state as stated in the Handelsgesellschaft case, or the principle that requires that any kind of tribunal that is going to establish a liability over an individual should be previously established by a law, as enshrined or as recognized in the Tadic case. Now we're going to speak a little bit about judicial decisions. I would say that judicial decisions is going to be maybe the second most used source of law that you're going to try to provide to the court in this kind of cases. However, you're going to have a problem with that. It's not a formal source, and it has less authoritative evidence. The very Statute of International Court of Justice says that there's subsidiary, and they will only cover the point in which you cannot, or that customary treaty and general principles of law cannot be applied, or where they're not covering that kind of obligation. That's very simple. The ICJ applies the law. It does not make it. You cannot tell me, or you cannot say that a previous decision of the ICJ is making law. In any event, it might recognize the existence of a rule of law, but by itself is not law, and is not going to bind the court to its previous decisions. And actually, as you may remember from Article 59 of the statute, there is not judicial precedence. So how are you going to use these judicial decisions? Is because ICJ and basically almost all courts and the law strive to judicial consistency. That meaning that if this court has already rendered a decision that solves a certain problems arising from a certain fact, then it is only logical that if that fact repeats itself in this other case or in another case, then the same solution shall apply. Law is a science. So for the same factors and from the same premises, the same solution should arise. This will make you, or is going to make you provide the evidence that the facts of the case that you are wanting the court to apply in this case are exactly the same in the relevant parts in order to apply that solution. And the first question that you're going to face when trying to do this is, but agent, those are not the same facts. In that case, this happened, and now in this case, this different thing happened. A good oralist in the Jessup competition will be able, first, to accept that yes, there are some kinds of inconsistencies and difference in the factual premises of the precedent and the case at hand. Second, recognize and explain the court why those inconsistencies or those differences are not relevant for the solution that he's offering, because the most relevant parts or the most relevant facts are actually the same. And so the solution should withstand and should sustain itself before the court. If you are able to provide that and you're able to present that kind of evidence, you're going to be very happy, and you're going to have a very, very happy panel of judges and at the competition. And also, if you're having a case that enshrines another rule of law, if you're having a case that says this is a general principle of law, or if you're having a case that says this is customary international law, your source of international law is not the case, it's not the judicial decision. Your source of international law is either this kind of principle, general principle of international law, or is this rule of customary international law? What is amazing and what is wonderful is that the court has already made you work, and it has already made the homework that you were supposed to do, because the court is going to say, this is customary international law, and we have noticed that opinio juris arises from this set of facts, and that state practice arises from this set of facts. So your source of international law and the source of international law that you should present is the rule of customary international law, not the judicial decision. The order or the argumentative correct order to present the source of international law is, I have a rule of customary international law that has already been recognized as such by this court in this case, and it has and you have considered that with this evidence of a state practice and with evidence of opinio juris, it was more than enough for the existence of the rule of customary international law. That will make you very happy oralists, and that will make us very, very happy judges. And finally, you also have to understand that not everything in a judicial decision is actually a source of international law. You have to make a decision, you have to consider, and you have to understand that one thing is obiter dicta, and another completely different thing is res judicata. Res judicata, as the principle says, is what was decided at that case. But while within the decision and in the reasoning, in order to get into that conclusion, the court may say some other things, even maybe go a little bit outside and try to explain something else. For example, in the Barcelona Traction Light and Power Company case, what was decided was whether or not a set of shareholders were entitled or were having the possibility to bring a suit against a certain state, and whether or not diplomatic protection was to be exercised over the shareholders of a company. However, within obiter dicta, at some point, the court, trying a little bit to react to some mistakes she made on the Southwest Africa cases, she decided to explain something about erga omnes obligations, and to advance a theory about about obligations that bound all the members of the international community in such a way that they give locus standi to any other country to bring a claim before the court. However, this is obiter dicta. This is not res judicata. This is just a commentary that the court made and shall be characterized as such. So, although it is part of a judicial decision, the source of law is not a judicial decision. That source of law is not a judicial decision. Also, you have to be very cautious about the fact that sometimes the court expresses the positions and the arguments of the parties, and then it takes the decision, the res judicata, whether they're going to accept or deny them. So if you're trying to present your argument that is exactly the same argument of one of the parties, and because it's just summarized in the judicial decision, you're going to try to present it as res judicata, you're going to fail miserably in trying to present a source of international law. Finally, the teachings of the most highly qualified publicist. My advice concerning this source of law is try to avoid it. It goes to lots of mistakes, and it goes to actually prove that you don't have anything better and you don't have anything else. And that will make your case look feeble and look extremely, extremely shaky. So let's try to analyze what they're saying in order to determine whether or not this can be a good source of international law for you. First, it says the most highly qualified publicist, not any doctrine. The source of international law that we're speaking about is not doctrine, as some of you say, is publicist. So if the person we're speaking about, or the person you're going to present to the court, is not a publicist, and if it's not a highly regarded publicist, then it is not going to be a source of international law. It is not useful for you, and it won't be of any good for you. So if we need publicists, which are the most highly regarded publicists, and which are kind of the teachings, or what we can consider within this as teachings of the most highly regarded publicist? It is not your professor of public international law in most of the cases, but if any of you has the privilege of having classes of any way with a judge of the International Court of Justice, then these do not apply to you. But in most cases, your professor of public international law is not a source of international law. The person that wrote an article that you believe that is going to give you the reason in the controversy that only you read, that have made a publication in a very obscure journal of international law in, I don't know, in the Western Sahara Journal of Public International Law, is not a source of international law. What can be a source of international law within this scope? The opinions of the of the judges of the International Court of Justice, that are mainly the dissenting opinions. And you're going to face then the problem that we're going to tell you, but that's a dissenting opinion. That means that the court decided in the other way. So, and also the dissenting opinions of international judges in other international tribunals that may be relevant to the controversy. So what I will recommend you is that in any way, the teachings of the most highly qualified publicist can be used as a source to identify either the existence of a new rule of international law, but they cannot be identified as a source, as recognizing the existence of another source of international law. Time and time again, what happens is that novel, not experienced teams come to the competition and try to say that this is a source of customer international law. Okay, and what's your authority on that? And their answer is, oh, I read it in, I don't know, at the Henkin. Henkin said so. So that's not the proof that there's customer international law. We already went in which the two elements and how you can prove those two elements of international law. Now, I would like to finish this part. And this final part is called the terrible, horrible, never good downward spiral of pain at the Jessup competition. That means that if you fail in providing the evidence or in the manage of the sources of international law within your intervention, then you're going to start having very angry judges that are not willing to let you advance in your argument. And you're going to spend maybe 20 minutes trying to explain why there's a state practice in some rule of customer international law. And that's painful for everyone. And so in order to ease that kind of pain, you can think about this beautiful kitty, or you can start trying of not committing these most common mistakes while providing the evidence of your sources of international law. And the first one I will say is, if you do not know your sources of international law and present the evidence when requested, then you're going to go in this downward spiral of pain. You should come prepared to say the source and present the evidence of everything that you are going to say before the court. Sometimes, and for some things, they are going just to pass through and no one is going to ask you any questions. Some other times they're going to ask, and we're going to ask questions about it. So your homework, your job is to come prepared. And no one is requiring you to have them by memory. This is not a test. This is not an examination. This is not a contest of who knows more. This is about who can present better the case and who can sell the case better to the panel. So you can come with little cards, a binder or whatever, and if required to present the evidence, take a moment and read the evidence that you have. And if you have it correctly, then you're going to avoid going into this downward spiral of pain. If you really want to impress the judges, then don't read anything and say it by memory. It will not give you lots of points, but it's going to impress some people. If you try to make up the existence of customer international and don't present any evidence or try to invent any evidence of customary international law, you are going in this downward spiral of pain. As we have said, the first thing that you have to do, or most of the things that you have to do, is to deal with customer international law and to present the evidence. One of the problems while presenting the evidence is most of the time you will mischaracterize national legislation. And there's a trouble. You don't know what the person in front of you knows. Time and time again, and this happens at least once every Jessup calendar in general. I have someone that tries to teach me Mexican law. And I just have to tell them no. And they really try to convince me that some kind of code of law in Mexico says what it doesn't say. So just don't try and do not mischaracterize the national legislation, because you're going to be in front of panels, and mostly in the international rounds, you're going to be in front of a panel from different nationalities. You're not going to know which are our nationalities, and basically you don't know what we know. If you think you have the magical case, and that means everybody wins everywhere and at the same time, it is very fun to have one team, the agent from the applicant, telling me that his case is going to be completely solved by, and usually there are arcane cases like Notre Dame is going to completely solve my case. A case from 90 years ago is going to solve completely my case. And then you go to the respondent and he says exactly the same. Yes, I have Notre Dame too, and it's going to completely solve my case. Please don't do that. There are no magical cases. Your case is not going to be solved by some arcane document or by some old document. The problem is so well thought that it's not supposed to have an easy solution as the one that you may want to present. Also, if you try to present a resolution, a study, a poll as an independent source of international law, or if you think that some kind of working group of experts is solving your case. Also, time and time again, we're faced with one oralist that says, oh, I found a working group from the International Red Cross Committee, and it says that I should win this case. And at that very same moment, the question is, and what kind of source of international law is that? And they just fall apart, and you will fall apart. Because if you think that's a source of international law, And if you think that with only that you're going to solve your case, you are going to be in very deep trouble. If you insist of presenting the teachings of a publicist, and you cannot justify who's this person, why is he highly regarded, or why, or if that person even exists, and believe me, it happens more frequently than you think, then you're going in this downward spiral of pain. If you have decided, or if you don't have any other choice than to say that your source of international law is the teaching of a highly regarded publicist, you have to present why he's a publicist, why he's highly regarded, and why does it matter for this case. Time and time again, and this happens also with the group of experts, when they try to present it as the teachings of highly regarded publicists. And it happened sometime with something running to some kind of geography issue they were having in one Jessup problem, and they were saying, yes, but the working group of the Geography Association of, I don't know, Austria is saying that we agree and that we should win the case. Perfect. Can you justify why, if there's even one publicist, who are the members of that working group? Why are they publicists and why are they highly regarded? And after that, we may be able to to consider in some way the existence of a rule of international law. In any event, if you cannot make a difference between obiter dicta and res judicata, as I was telling you, you are also going in the downward spiral of pain. If and this is quite recent, but it's beautiful. It's a beautiful example. I had one oralist that tried to tell me that in accordance with the Nicaragua case, non-intervention was a rule of jus cogens. That sounded strange enough for me for requiring the paragraph in which he said so. And he was somewhat right, because it was one of the summaries of the arguments that said in that paragraph, Nicaragua is claiming that non-intervention is part of, is a rule of jus cogens. And in the next paragraph, the court says, and we're not going to decide upon that. So this kind of mischaracterization that he's providing, or that oralist provided, put him in this downward spiral of pain, because mainly then you have two options. Either he's blatantly trying to lie and to try to fool the court, or he just doesn't know what he's speaking about. None of those answers are going to be correct for him, and you're going to be just completely thrown up to the wolves in that case. In any event, if you quote as your evidence of customary international law an article, a book, a case, your professor of international law, myself, Claudia Cáceres, or anyone else, and you don't present the evidence of customary international law that you're required to, you're going to spend 30 minutes or 20 minutes trying to provide that evidence, and that's going to be extremely, extremely painful. In summary, we know you know. You're going to do your work, you're going to do your homework, and I really hope to see you in a couple of months in Washington. Most of the time you know that what you know, and you're going to know a little bit more than us in a certain topic of law. However, you should be able to demonstrate it, and you should be able to demonstrate that you know the basics, and you know, and the most basic thing that you have to demonstrate is that you can construe a rule of public international law. After you have done that, we can start talking about the specifics of the case and how much you studied about, I don't know, satellite telecommunications in the 21st century or whatever irrational topic you are required to study for this year. So just present the evidence to the court, and you will be okay. Thank you very much. And my last piece of advice is enjoy your Jessup. It can be a very, very wonderful time, and I'm sure that you're just going to do great in this case.